Good morning. My name is Elaine Deloach. I am a Myasthenia Gravis volunteer. I also am a lawyer by profession. From January of 1989 until January of this year, I was employed by the Social Security Administration in the Office of Hearings Operations. That is the part of Social Security that does handle disputed disability claims. I started back in 1989 actually working for an administrative law judge, writing decisions, saying why people should be granted or denied benefits. I then moved into management, and in August of 2010, I received my appointment. My husband, Steve, was also an attorney. In December of 1990, he came to work for Social Security, and we worked together until his passing in February of 2016. He also started as a decision writer, went into management, and he was appointed an administrative law judge in 2008. I am not here as a representative of the Social Security Administration, but I am here as a volunteer. I am going to be available to assist people and help people with questions they may have regarding Social Security disability benefits through the MG Friends program. You can contact Nikisha Betzel. She will then give your information to me, and I will be getting back with you. It will not be direct contact with me because Myasthenia Gravis needs to keep track of these volunteer activities to see if this is something that really serves the community. And so if we don't go through the national office, they have no idea how many people I may be talking to. This program is being recorded, and there is a PowerPoint that's also going to be available on the app. Now, there's one other website that you need to be familiar with, and that is the Social Security website, which is ssa.gov. It is written in plain English, and it is user-friendly because the administration is trying to get people who are applying for any type of benefits, retirement, disability, survivor's benefits, to do this online because of the sheer volume of work that they handle. So let's talk about what happens when you do want to apply. You have been working, you are no longer working because of your condition, you want to apply for disability benefits. You can do it online, or you can call the Social Security phone number and make an appointment and go into your local Social Security office. But again, as I said, they prefer that you try to initiate everything online to the extent possible. You will fill out an application at that time, giving your name, your Social Security number, when you believe your disability began. They will also have you fill out various other forms providing information regarding your work history, your income. If you are still working, you may be working part-time or have taken a reduction in pay, and they need to know about that. And your activities of daily living. What are you still able to do? What are you having problems doing? The names of your medical providers. When you apply, you're going to see that there are actually two types of disability benefits that the Social Security Administration administers. One is a disability program based on people who are working and paying into the Social Security system. Part of that FICA assessment that you pay goes into your retirement account, and part goes into a disability account. The other benefit that we administer is the Supplemental Security Income Program. The criteria for being disabled for either program is exactly the same. The eligibility for the two programs is different. For the disability program where you have paid into the system, it's based on you actually having paid into the system and being what Social Security determines is insured. For SSI, this may be someone who was working sporadically and never really paid in the system on a regular basis, or worked a long time ago and then hasn't worked for many years, or someone who has never worked at all. It may be a very young person. It may be someone who, the typical is a woman who married and never worked outside of the home, but now has a disability. With the SSI program, it is a needs-based program. So there are income and resource restrictions that you have to meet in order to qualify for those. And some people, because they had jobs that are very low paying, actually qualify for both benefits. They get their Social Security, and then they get enough SSI to bring them up to a certain monetary standard. With your Social Security disability benefits, you qualify for Medicare, but there is a catch. The Social Security disability benefits have a 5-month waiting period before you draw your first check, and it is a full 5 months. So if you're found disabled any day after the first day of a month, you have to wait 5 more months, and essentially almost 6 months before you draw a check. Once you start drawing your benefits, you have to wait another 24 months before you are eligible for Medicare. You would automatically receive Medicare Part A, which is the inpatient benefits. You have to opt to choose Part B, which are the outpatient benefits. And I will caution you, if you say, oh, I don't want the outpatient benefits now, and you later sign up, you will pay a penalty for not signing up timely. So it is important that you consult someone if you think you want to pass on those B benefits and make sure you're doing the right thing. Social Security probably will not advise you one way or the other and tell you it's up to you. But there are people who can give you some advice. I know in the state of Louisiana, the insurance commissioner's office will help you make some of these decisions. With SSI, you automatically qualify for Medicare and Medicaid, and you start receiving your Medicaid benefits as soon as your checks begin. So the first month that you're found entitled to a check, you are going to be Medicaid covered as well. So you've given all this information to Social Security. You've told them your history. What are they going to do with all this stuff? Well, we have a 5-step sequential evaluation process. The very first step is, are you engaging in substantial gainful activity? This would affect the person who may still be working. He's had to reduce his hours. He's changed his job. If that person is drawing more than $1,220 per month in gross income for 2019, he is not eligible for disability, regardless of his medical condition. We don't even get to the medical condition. Now, there are some things that will reduce that income. They're called income-related work expenses. For example, if the only reason you're able to work is that you have a service pick you up every morning and bring you to work and you're paying for that, or the only reason you're able to work is because you are spending X number of dollars per month on your medications, expenses like that can be deducted from that income. The other thing that Social Security will consider in determining that income, let's say you're getting $2,000 a month. Are you really earning that $2,000 a month? Or is your employer subsidizing your income? Is he saying, you know, Tommy here has such a wealth of information about this business, even if he can only come in 10 hours a week, I need him because he has that institutional knowledge that we need, and no, his work's really not what we're paying him, but I need him to come in and I'm trying to help him out. So we may ask the employer, what is Tommy's work really worth? Or, yes, we don't make him make as many widgets during the day as everyone else. He doesn't have the same production quotas, but we need him because he's the one that can tell us how to fix the machine when it jams up because he's been here forever. So what is his work really worth? Assuming that you get past that hurdle on the income, and most people do because, quite frankly, very few of the people that ever appeared before me or that I saw in the 30 years that I was with Social Security were continuing to work. The next question is, do you have a severe impairment or combination of impairments? Now, I'm going to tell you a little story that I think emphasizes what is a severe impairment. Many years ago, when I was a supervisor, to help the staff out, I would go out and meet with people who were applying for benefits but did not have a representative for their hearing before the judge, and go over their record with them and explain to them what the procedure looked like and get them to sign some releases. So I go out and meet this gentleman, and we're sitting in a conference room, and I'm going through his medical records with him. And everything in the medical records talks about how he had been a pulpwood cutter. And I don't know how many of you are familiar with pulpwood cutters, but I can tell you their tool of the trade is a chainsaw. And maybe McCullough and all the rest of the people who make these chainsaws don't want you to know this, but if you work with one, eventually you will lose part of your body. Something is going to get cut off. And he came in and had lost the 3 fingers on this hand. And that's all the medical we have, is the 3 fingers on his right hand. So I'm talking to him, and we're going through the medical about the 3 fingers being amputated and this, that, and the other. And I go to get him to sign a form. And when I do, he starts moving it back and forth. And I said, "Are you having problems seeing that form?" "Well, you know I'm blind in my left eye." "Really? When did that happen?" "Oh, I was 12. My brother shot me in the eye with a BB gun." "Huh." So then I said, "Well, here's the form, and here's where you need to sign it." And he brings up his left hand, and he's got 2 fingers. And I was so shocked. I said, "Excuse me, you only have 2 fingers on your left hand." And he said, "Well, yeah." "Well, when did that happen?" "Oh, about 5 years ago." Well, when he still had this whole hand and these 2 fingers and that one eye, he was still out there cutting trees with a chainsaw. He didn't think he was disabled until he lost those 3 fingers. So that's all he reported. Didn't tell us about any of the rest of this. I got him to sign the forms and hot-footed it back to the courtroom and said, "Judge, we got a problem." He said, "Well, what?" I said, "You know your 3-fingered man?" He said, "Yeah." I said, "I'm sure you're thinking 3 fingers, 2 eyes, 5 fingers?" He said, "Yeah." I said, "Think again. Think 2 fingers, 2 fingers, and 1 eye." He said, "You're kidding me. I don't have any medical about that." I said, "Yeah, but I think you can note on the record, no fingers on the 2 fingers on the left hand." And we ended up paying the man. And that's what happens with a lot of people. They may have other issues going on, but they don't think that that is what disabled them. My husband, for example, had myasthenia gravis. As a consequence of that, he also developed diabetes. He also had thrombocytopenia. He also had hypertension. You need to report everything that's wrong with you, because it may not be one in itself that disables you, but the combination of things that disables you. Once you've listed what you are ailing with and what you're being treated for, and is it severe, Social Security has a listing of things that the commissioner has said, these things are so severe, if you meet this criteria, you are disabled. Some of these things are, for example, having to use a wheelchair, which in our terms, or Social Security, is that you cannot ambulate effectively. You have to have assistance to walk. You're using a walker, that's another one. Because if you're using a walker, you can't use your hands for other work activities. You're holding something with both hands as it is. With myasthenia gravis, the listing is very specific, and it talks mostly about the difficulty swallowing and the facial. It does not refer to how many crises you have or things like that. So you can't, in my 30 years, I never saw anyone who met the myasthenia listing, I'll be honest with you. But that doesn't mean you're disabled. It just means that you don't meet that criteria. The final 2 steps are based on work. One is, can you do the kind of work that you did in the past? And Social Security looks at that job in 2 ways. They look at how you actually did it, and then they look at how it's commonly done in the national economy. And there's a reason for that. we have vocational experts that come in and describe your work activity and tell us how it's commonly done. Well, determining how a job is commonly done is based on a survey in the job market. And as you can imagine with any survey, there are always extremes. You may be a cashier and never lift more than 5 to 10 pounds and be able to sit at a stool. You're at the cashier at the A&G cafeteria and you sit at a stool, but you're a cashier. You're a cashier in Walmart and you're lifting 50-pound sacks of dog food, and you're a cashier in another store in Hallmark and you're lifting 10 to 20 pounds. So they survey all of these jobs and say, well, what is the average? And the average for most cashiers is that 10 to 20 pounds, and we're going to say that the job is light, even though you may have done it as medium work or you may have done it as sedentary work. So that's why they look at it both ways. You were a cashier at Walmart and it was medium work, but the cashier job is light. So can you do them as you did it or as light work? You were the cashier at the A&G. Okay, can you do it as sedentary work? Can you do it as light work? To make these determinations, the judge or the adjudicator will first make a determination of your residual functional capacity, and that is, what can you do in spite of your conditions? This is related to not just what you can physically do, but what can you mentally do? And that's very important because there are conditions that affect your mental function. There are conditions that affect your physical function, and the adjudicator needs to take all of that into consideration when making this assessment. Now, for someone with myasthenia gravis, the issue is not always what are you physically capable of doing, what are you mentally capable of doing. There's an added component of that, and that is, can you do this job on a regular and continuing basis? That is, can you do it 8 hours a day, 5 days a week, with sufficient regularity that you're not only going to be hired to do the job, but that you're going to be able to keep doing the job? So that raises issues of attendance, breaks during the day. How is your condition impacting your ability to sustain that work? I know my husband personally could always do sedentary work. The issue for him would have been, can you sustain it over a 40-hour work week, week after week after week, and just take ordinary vacation time off, or acceptable absences for other leave, medical appointments, things like that? Are you going to have more than what an employer would say are an acceptable number of absences? Because if you are, odds are they're not going to keep you. You know, they need someone there doing that job on a regular basis. They need to know that you're going to be reliable, that if your shift says you report at 9 o'clock, that you're going to be there at 9 o'clock. You might be late once in a while, once a month, but not once a week. You may have to leave early once in a while, but not once a week, twice a week. That is not going to be acceptable for most people. Are you having to have extra breaks? Are you able, most employers expect you to be able to work about 2 hours and then get a 15-minute break, 2 hours, take a lunch break, 2 hours, get another 15-minute break, 2 hours, and your day is done. Well, if you need to leave your workstation every hour and you're working as a cashier, that's not going to work. They need someone there who they know they can rotate someone in to cover for your 15-minute break. They don't have someone floating around to come in every hour to cover for you. Or do you need unexpected breaks? Well, if we can't cover when we know you're going to go every hour, how are we going to cover when we have no idea when you're going, but you've got to go now? These are expectations we cannot expect an employer to carry for most people. As you move into management and upper white-collar jobs, there's a little more flexibility. I know when I was a manager and even as a judge, I could get up from my desk and wander around the building anytime during the day. But if I was a technician and supposed to be preparing cases for that judge to hear, there's less tolerance for that. We're waiting on you to move that case so that we can move it down the line. Go back to your desk and go to work. When I was a supervisor, I could always say, well, I'm supervising by walking the floor and seeing what people are doing. So what if I was just walking the floor because I was tired of sitting in my office? And has your employer changed your workload? Have they made accommodations where they, as I said at the initial, where they expect you to do less than anyone else? They value you, and I have actually seen this. In fact, one of the cases that stands out in my mind is a lady who worked for Popeye's Fried Chicken as a cook. Now, you wouldn't think that that would be a really high-skilled, valuable job, but she had been at that Popeye's outlet for 15 years, and she knew every in and out of that store like nobody's business, and knew how to troubleshoot when there was a problem. And they told us, they said, we keep her here and we pay her not because she does anything. She basically sits in the office and may come out and walk through the kitchen every once in a while and tell everyone what to do. We keep her here because she knows how to operate this business, and she knows how to fix the problems if they come up, and she's the manager's right-hand person and his go-to guy, and he would be lost if he didn't have her there. So they had reduced her. She was not a cook. If you asked her, well, what was your job? Well, I'm a cook, and I have to lift these sacks of frozen chicken and these sacks of flour and do this and do that. Well, was she really doing it? No. So it was an accommodated work. You filed your application. You've given all your information. You've gotten your doctors to write letters on your behalf, and let's talk about that, your medical records. One of the things that I, as a judge, looked at when people would come and tell me their story, and appearing before the judge is really the first time that you're going to see a person face to face and get to tell your story. I wanted to see what you were telling me appeared in those medical records. And yesterday I sat in a seminar where they talked about communication, and one of the points I brought up was, as a caregiver, it used to just rub my fur the wrong way when my husband would go to the back and say, I don't want you to come back with me, you don't, just stay out here. And when I would come back, well, what'd the doctor say? Everything's fine, I'm doing good. You were back there 20 minutes and he said fine and good, and that's it? And reflecting on it this morning, I realized that's what the doctor said, because when the doctor would say, how are you doing, Steve? I'm doing good. Well, how do you feel? I feel fine. And he may have felt good and he may have felt fine that morning of that visit. But was he telling him everything that had happened since the last visit? So it's very important when you go to your doctor to be sure not just to focus on what's going on today, but to tell them how you've been doing. You know, since the last visit, I've had to have a reduction in my hours at work. Since the last visit, my employer and I have had a talk about, is it really viable for me to keep working? Since the last visit, I've had to give up driving and someone takes me to and from everywhere I want to go. Well, how are you feeling symptom-wise? I'm fine. I'm not having any symptoms today. But that's not the whole story. The whole story is, I'm not having symptoms today, but my condition's causing these effects. So it's very important that you give an accurate description of what's going on with you. Not only does it help your doctor make his diagnosis, it gives a better history when it comes to filing a claim like this. For example, someone comes in and I've sworn them in and I'm saying, now I see in your report you've alleged that you have headaches. How often do you have headaches? Oh, I have a headache every day. Well, how long does it last? Oh, it lasts 3 or 4 hours. Well, what are you taking for it? Well, I'm taking Tylenol and I'm laying down in the dark. Okay. And I go through the medical records and I see the introduction on every visit where someone, probably a nurse or a nurse practitioner, has gone over the review of systems, and it has neurological headaches, denies. What I always thought was, why are you telling me more about what's wrong with you than your doctor? The only thing I have to give you is a check. Your doctor might have some kind of treatment. And my feeling was, if the symptom wasn't bad enough for you to tell the doctor and for the doctor to put it in your records, I'm not giving it a whole lot of credence either, because I know what you're looking for. When I was in insurance defense, we used to call it the greenback poultice. You know, you lay a dollar bill on someone and they start feeling better. So you've got to make sure that your records reflect you. And I know you feel like the doctor's rushed and everything else, but at some point you have to say, wait, this is my appointment. It's not your appointment, it's my appointment. Listen to me, listen to my story. So be sure to tell your doctors if you're having intermittent numbness, that if you type it, you're at work, and if you're typing on the keyboard, you have to stop after 30 or 40 minutes and let your hands rest for 5 minutes before you begin again. Because something like that may be the very linchpin that makes that administrative law judge say, well, you know, this person is disabled. There is something wrong there. There is something going on. Once you've filed your application and you've provided all your information, Social Security has a variety of dispositions that they can issue. At the very initial step, they may say, yes, you're disabled, and that's the end of the process as far as you're concerned. You're disabled. You're going to get a letter telling you how much your benefits are, when they will start. You may get a letter telling you, sorry, we don't find that you meet our definition for disability. It will have an explanation in there, although sometimes it's not always the clearest, but it will have an explanation saying why you were denied. It will also have information in there telling you how to appeal that decision. Now, in 40 of the states in the United States right now, that notice will say your next step is to file a request for reconsideration, which means that those same examiners and doctors who looked at it the first time, it's a state agency called Disability Determination Services, your claim will go back to them. Another panel of examiners and doctors will look at it and decide whether or not you're disabled. They will issue you a notice. In 10 of the states in the United States, that step has been eliminated, and you will get a notice that says, file a request with an administrative law judge. In the states where you have to go through reconsideration, the next step is file a request for a hearing before an administrative law judge. This is the one time you are going to meet someone face to face and be able to tell your story. So it's very important that you have everything ready to go and be able to tell your story. At the hearing, you can have a representative. It can be a lawyer. It does not have to be a lawyer. There are many paralegals who've appeared before me who do just as fine a job as many lawyers. It should not be a family member or a friend, because that person wants to tell me what they know about you, and that's a witness. That's not an advocate. So most advocates now, attorneys and paralegals, use a fee agreement, which says that they will collect a percentage of your past due benefits if you're found entitled to benefits, and that if there are no past due benefits for whatever reason, or you're denied, you do not owe them a fee. If the judge denies your claim, you have the right to file a request for review with the Appeals Council. Again, this is an administrative process. It's in Baltimore and Falls Church, or where the administrative judges are that do this. They will issue a decision, and then if you are still adamant that the decisions are wrong, you can file in the federal court system. You do not have a hearing in the federal courts. It's all done on the record. The other types of decisions that Social Security can issue are partial decisions. One says you're disabled now, but you weren't disabled on the date you alleged you stopped work or your disability began. Something happened since then. That something that happened since then could be a change in your age. Social Security has a grid rule. It applies for 3 different categories of work: sedentary, light, and medium work. And it looks at your age, it looks at your education, and it looks at the kind of work you've done in the past. The older you are and the less you can do, the kinder the rules are to you. So 50-year-olds who are limited to sedentary work have a great chance of being paid. They are less employable. They are less competitive in the job force. People under 50, it's more difficult to pay because they are more competitive. The less education you have, the less competitive you are. You may have a change in your system or a change in your decision because think of myasthenia gravis. It's a lot like any other disease. It's a lot like diabetes. It's a lot like depression. There are grades of symptoms. You may be diagnosed and at the very beginning have very mild symptoms. And yes, they cause you some problems, but they really wouldn't prevent you from working. But then the symptoms have gotten worse over time and now you can't work. Or people with diabetes, they generally start with diabetes, they're taking their medications, everything's fine, but as time goes on, they start developing numbness and neuropathy in their hands and their feet. And suddenly they can't do those jobs that require a lot of fingering because they don't have that feeling in their fingers, or their fingers are numb. Depression and mental illness are things that are very hard to grasp in many ways because they kind of ebb and flow. Sometimes you have really bad symptoms, and then you may have periods where it's under control. But then something happens and you crash again, and it may take a longer time to recover. So the judge may be saying, well, for this first year, you really, yes, I'm not saying nothing's wrong with you, but it didn't keep you from doing some kind of work. But then something happened and it's worse. And now it's not getting any better, and I'm going to find you're disabled from this date forward. The other type of partial decision that we issue is the one that says, yes, when you say your disability began, it began, but you got better. They found the drug that you respond to. Your symptoms have gone in remission. They've been in remission for the last 12 months. So you could go back to work. You can appeal any of these decisions, any of the partial decisions if you disagree with it, the denials certainly. When you do, just be aware of one thing. I have seen cases where a judge gave someone a closed period and they appealed it, and the appeals counsel came back and said, not only are you not disabled now, you weren't disabled during the period the judge said you were. We'll let you go and try again. And now I have to write a new decision justifying my first decision even more so than I did the first time around. Or there may be new evidence that really does show my first decision was wrong. So this person comes out with nothing. So you have to be a little savvy about what you're doing when you're appealing these decisions. As I said, the most important thing for you is talking about your symptoms. And it's very hard to say, what is pain? God knows, I wish when I was a judge I could have just put something on their finger like the pulse oximeter, and it said, oh, his pain is an 8. Instead, what would typically happen is I would be sitting there, are you having any pain? Oh yes, I have pain every day, all day long. Well, on a scale of 0 to 10, how bad your pain? You know, my pain is a 10. Really? You look pretty calm for a person whose pain's a 10. One thing I've decided, every administrative law judge could play professional poker because we have to keep the straightest faces no matter what people tell us. So when they're telling me their pain is a 10 and it's the worst pain they can imagine and they're sitting there just chatting away, or how anxious they get and how nervous they get, and you just don't understand how anxious I get. When I'm around strangers, I just can't hardly talk. And I'm thinking, I don't remember knowing you. But apparently I don't make you that anxious. You're able to talk to me. Get a good relation. If you're going to apply for benefits, tell your doctor you're going to apply. A lot of times, your best advocate is your doctor. Now, I have had some, I will tell you, a doctor sending a prescription slip that says, Mr. Smith is disabled? I don't know. I have to have a little more than that. But if they will take the time to write a narrative report that shows what they've done, how they've had to change your treatment perhaps because you weren't responding, complications that you had from treatments, side effects that you had from medications, a good comprehensive report from a treating examiner can certainly change the tide of that claim, because otherwise I may be looking at the opinion from a doctor who's just read the records and is drawing his own conclusions, and he may be missing things that your doctor knows about you. So it's very important that you get your doctor on board. You can have other evidence. I typically did not use a lot of witness testimony, for example, having the spouse come in, having the husband come in, having the caretaker come in, because a lot of it was just repetitive and they would just tell me what I had already heard. But sometimes it does help to have a spouse come in. If part of your problem is that you're having forgetfulness or having cognitive problems, it may be that I need that spouse in there to really explain to me what's going on. Because unfortunately, what happens in a lot of hearings is the claimant comes in and wants to underplay what's wrong with them. Well, are you having problems remembering things? Oh, no more so than usual. I have no idea what usual is, but okay, and they don't really want to tell me a whole lot more. But then I get the spouse in there and she tells me what's going on and how he got lost in the backyard and couldn't even find the door to get back in the house. Or, she's had to go get him because he got lost driving to the grocery store down the street, and it's someplace that they have used for the last 30 years. So they can help in instances like that.